Hi, I'm Attorney Jennifer Witt with the Witt Law Group. Have you been court ordered to do a chemical dependency evaluation, or perhaps you need to do one for your family law case? Well, stay tuned. I have a couple of hints that you should know before you head off to that evaluation. And if you like this information, please subscribe and stay tuned. Chemical dependency evaluations are one of those things that creates a lot of anxiety for most people in the criminal justice system. And I know some of you watching, maybe you're submitting to an assessment or evaluation because you're in a family law case and your guardian ad litem or attorney or judge has directed you to do that. And some of what I'm telling you is relevant to that as well. But this is really directed more at criminal defense clients who know that they need to do one or have been ordered to do one. And here are just 3 tips I have for you that hopefully will make the process smoother and kind of educate you as to what you need to know before you head off for that evaluation. Number 1, make sure, this is very critical, that you are going to a state certified agency. Sometimes people will come to us or call us and say, hey, I'd like you to handle my DUI case, and I've done some of these proactive steps. But unfortunately, their proactive steps are not at an agency where we could use the evaluation. So, or they have a doctor write their opinion about their use or lack thereof abuse of substances. That won't work. And the reason is these reports, when we finally file the report, there will be a short form that will list certain documents that had to be reviewed by the evaluator. And also, don't get caught up. Many of us interchangeably use evaluation, assessment, drug and alcohol assessment, chemical dependency assessment, substance abuse evaluation. It's really all the same, but what you're looking for is a state certified agency. And what's critical about that, which brings me to point number 2, talk to your lawyer. Wherever you are in the country, if you're in the state of Washington, your defense lawyer in Washington, what do you need to have provided to the court or probation? We are very specific with our clients. If you come to our firm, we have certain agencies we want you to go to in the area, and more specifically, a couple that we do not want you to go to. And the reason is twofold. Number 1, there are some agencies out there that essentially, there is financial incentive to find more individuals have an issue because they get paid to perform the treatment as well as the assessment. Most of them are really pretty good and do a fair job and give you a fair shake. Some don't, and that's relevant. But more importantly, which is the second point, they don't provide documents in a timely fashion. And they don't understand, if you don't give us the compliance report, for example, if you've been ordered to do weekly meetings and group sessions and you have to do that for 12 weeks, we have to provide probation or the court that document, that you have been that you're in compliance, and we have to do it by a certain time every month. If your agency says, well, we don't get around to it till the 15th, or oh, so-and-so's out for the week, that's a big problem for you. And many prosecutors will file what's called a motion to revoke because you're not in compliance. They don't have a record of your compliance. So when your defense attorney says, hey, steer clear of this agency, recognize there could be an issue at the outset, but also an even more important issue when the case is resolved. You do not want to create problems for yourself by having an agency that doesn't understand the magnitude of timely filing of documents. So that also dovetails with those of you who are in the military. The military frequently wants to do their own evaluation, and your command will require it, which is fine. But what we see is the military frequently wants you to do more treatment than the civilian side. So what we want to file is generally speaking, is we would want you to do a civilian side evaluation and file that. Again, also not just because you will be required to do more treatment on the military side on average, but they are very difficult to work with as far as on the civilian side, trying to get the evaluation in a timely way and trying to get proof that you are in compliance. Sometimes they send us the assessment and not the updated compliance reports or vice versa, and it just is a mess. So if you're in the military, don't be surprised if your defense attorney says, great, do what your command says, go get that evaluation, do whatever they order you to do on the military side, but realize we're going to want a civilian side report and compliance reports as well. It reduces the odds that at the end of the case you will be in trouble with the prosecutor or probation for not filing compliance reports. Finally, number 3, don't mess with your UA. People are, I'm sure if you're watching this video, you might be one of those folks. How do I trick the UA? I'm concerned I was drinking last night, or I use marijuana regularly. I don't want it to show up on the eval. Don't do that. If anything, talk to your lawyer. Can you push that assessment or evaluation out another few weeks or a month? The tests are so precise. Even actually more than we realized, because we had a client who consumed alcohol at a party almost a week before the evaluation, and she's asked us, and we're like, yeah, I don't think that should be fine. And maybe there was more consumed in the interim, but from what we knew, there was a buffer, and it was positive for alcohol. The problem, again, sometimes our clients will say, well, it's legal, alcohol and marijuana is legal in Washington. However, if you've been to your arraignment and the judge has directed you, as most do on a DUI, do not consume alcohol or drugs while your case is pending, obviously it appears that you are. Maybe not for marijuana, maybe it's just residual, but it won't look good if you're testing positive for alcohol while you are not supposed to be consuming alcohol during your case as it's pending. So again, but what I want to point out is it will show positive. If you try to dilute your UA, by drinking a lot of water or taking supplements, that is a presumptive positive. So you're not really beating the system. It just looks like you tried to mess with the test, which again is a presumptive positive. So hopefully that helps you out. Remember, state certified agency, talk to your lawyer about whether it's a good agency that will provide updated compliance reports in a timely way. And if you're military, if that's an agency you should also be using and getting a civilian side report. Number 3, don't mess with your UA. Just talk to your lawyer. How much time should you be waiting, and stop using any substances well in advance beforehand. So hopefully that helps you out. Thanks for watching.